You just walked into a gas station with your concealed carry permit and your legally owned firearm. You're breaking the law, you didn't see a no-gun sign, there was no notice. But in Hawaii, and potentially in several other states soon, that doesn't matter. Because the rule just got flipped upside down. It used to be that you could carry your gun anywhere except where signs said you couldn't. Now, in some states, you can't carry anywhere unless a sign explicitly says you can. Welcome to the vampire rule. And if a case called Wolford versus Lopez goes the wrong way, this nightmare could spread across America. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal could turn every store, every gas station, every private business into a prohibited zone for concealed carriers. 90% of gun owners have no idea this legal battle is happening right now. Hit that subscribe button so you never miss updates on cases like this that could make legal carry impossible in your city. Here's what's happening right now that you need to know about. Hawaii passed a law that flips the default rule for carrying firearms on private property that's open to the public. Under the old rule, which most states still follow, you can carry on private property unless the owner posts a sign saying no guns. That makes sense. If an owner doesn't want guns on their property, they post a sign. If there's no sign, you're allowed. But Hawaii's new law reverses this. Now, you cannot carry on any private property that's open to the public unless the owner posts a sign explicitly allowing firearms. That means every store, every restaurant, every gas station, every shopping mall is presumptively off limits unless there's a guns allowed sign. And here's the trap. Almost no business is going to post a guns allowed sign. Why would they? It's controversial. It might scare customers. It might create liability concerns. So the default becomes a total ban. Concealed carry permit holders in Hawaii can't carry anywhere except in their cars and in their homes. Everywhere else is illegal. That's the vampire rule. And gun rights groups sued, arguing it violates the Second Amendment. The case is Wolford versus Lopez. Lopez is the Attorney General of Hawaii, and right now the case is working its way through the courts. And the outcome is going to determine whether this model spreads to other states. Let me break down what Hawaii's law actually does, because the details are where people are getting trapped. Under Hawaii law, any private property that's open to the public is considered a sensitive place where firearms are prohibited unless the property owner gives explicit permission. And explicit permission doesn't mean the owner just doesn't object. It means the owner has to post a sign or give written notice that firearms are allowed. If there's no sign, carrying a firearm is illegal, and the penalties are severe. If you're caught carrying on private property without permission, you're committing a misdemeanor. That's up to 1 year in jail and a fine of up to $2,000. And you lose your concealed carry permit. Your gun rights are suspended. All because you walked into a 7-Eleven that didn't have a guns allowed sign. Now here's what most people don't realize about how this works in practice. Let's say you're a concealed carry permit holder in Hawaii. You need gas. You pull into a gas station. You walk inside to pay. You're carrying concealed. You look around. You don't see a guns allowed sign. Technically, you're now breaking the law. You should have left your gun in the car, but you didn't know. There was no warning, no sign saying guns prohibited, just the absence of a sign saying they're allowed, and that absence makes it illegal. Now imagine a cop happens to be in the gas station. He sees the outline of your gun under your shirt. He asks if you have a permit. You show him. He asks if the property owner gave you permission to carry here. You say, "What?" The cop says, "Under Hawaii law, you need explicit permission." You say, "There was no sign saying I couldn't." The cop says, "There's no sign saying you could." That's what matters. You're getting cited. Let me give you another real-world example. Imagine a woman named Sarah. Sarah lives in Hawaii. She has a concealed carry permit. She's been carrying legally for years. One day she goes to the grocery store. She's carrying her handgun concealed. She's shopping. She's not bothering anyone. An employee sees the outline of the gun. The employee calls the manager. The manager calls the police. Police arrive. They ask Sarah if the store gave her permission to carry. Sarah says, "I have a permit. I thought I was allowed." The police say, "Not on private property unless the owner explicitly permits it. Did you see a guns allowed sign?" Sarah says no. The police arrest her. Sarah is charged with a misdemeanor. She loses her permit. She spends thousands on a lawyer, all because she assumed the same rules applied that apply everywhere else in the country. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the 3 states most likely to copy Hawaii's vampire rule in 2026. Number 1 is already drafting the bill. Subscribe right now so you don't miss it. Now, let's talk about the constitutional argument, because this is what the courts are going to decide. The plaintiffs in Wolford versus Lopez are arguing that Hawaii's law violates the Second Amendment as interpreted by the Supreme Court in New York State Rifle and Pistol Association versus Bruin. Bruin said that the Second Amendment protects the right to carry firearms in public for self-defense, and regulations on that right have to be consistent with the nation's historical tradition of firearm regulation. The plaintiffs argue that there's no historical tradition of banning guns on all private property open to the public by default. Historically, property owners could exclude guns from their property, but the default was that guns were allowed unless the owner objected. Hawaii flipped that default. And that flip has no historical analog. Therefore, the law is unconstitutional under Bruins. The plaintiffs also argue that the law makes it effectively impossible to carry for self-defense in public. If every store, every business, every public-facing private property is off limits unless there's a sign, and no one posts those signs, then permit holders can't carry anywhere. That defeats the purpose of the Second Amendment, right recognized in Bruin. You have a right to carry in public, but Hawaii made it so you can't actually exercise that right. That's a violation. But here's Hawaii's counter-argument. The state says that private property owners have rights too, and one of those rights is to control what happens on their property. If a property owner doesn't want guns on their property, the state can enforce that preference. The state argues that requiring affirmative permission from property owners is a reasonable way to balance Second Amendment rights with property rights. The state also argues that there is historical precedent for respecting property owners' wishes. If a property owner didn't want guns, they could exclude them, and requiring permit holders to get permission is just enforcing that historical right. But here's the problem with that argument. The law doesn't actually respect what property owners want. It imposes a default ban regardless of what the owner wants. A lot of property owners probably don't care if someone with a permit carries in their store. But under Hawaii's law, unless they affirmatively post a sign, the default is prohibition. So the law doesn't protect property rights. It creates a blanket ban using property rights as an excuse. Now here's why this case is so critical beyond just Hawaii. If Hawaii's law is upheld, other anti-gun states will copy it. California is watching, New York is watching, New Jersey, Illinois, Washington, Oregon, all of them. If the courts say this model is constitutional, these states will pass identical laws. And suddenly, concealed carry permit holders across the country will face the same problem. You can't carry anywhere in public because nowhere has a guns allowed sign. And here's what that means in practice. Imagine you live in a state that adopted Hawaii's rule. You have a concealed carry permit. You want to run errands. You need to go to the bank, the grocery store, the post office, and the pharmacy. The post office is a federal building, so guns are already banned there. Fine. But now the bank, the grocery store, and the pharmacy are also off limits unless they have guns allowed signs. You drive to the bank, no sign. You leave your gun in the car. You go inside. You come out. You drive to the grocery store. No sign. You leave your gun in the car again. You shop. You come out. You drive to the pharmacy. No sign. Gun stays in the car. By the end of the day, you've left your gun in your car 6 times. Every time you do that, you risk theft. Someone could break into your car and steal your gun, and then you'd be liable under some state's storage laws for not securing it properly. But you had no choice because you couldn't carry it inside. Now, quick legal note. This is educational information, not legal advice. If you're affected by laws like Hawaii's, or if you want to support legal challenges, consult with an attorney or donate to organizations like the Second Amendment Foundation or Firearms Policy Coalition that are fighting cases like Wolford. Now let's talk about what's happening in the courts. Wolford versus Lopez was filed in federal district court in Hawaii. The plaintiffs asked for a preliminary injunction, which would block the law while the case is being litigated. The district court denied the injunction. The case went to the Ninth Circuit Court of Appeals. The Ninth Circuit also denied the injunction, so right now, Hawaii's law is in effect. Permit holders in Hawaii are subject to the vampire rule. The case is still being litigated on the merits, but that takes time. We're talking years. And in the meantime, the law stands. Here's what to watch for as this case progresses. If the district court rules in favor of Hawaii, the case will be appealed to the Ninth Circuit. If the Ninth Circuit upholds the law, it will likely be appealed to the Supreme Court. And that's where the real battle will happen. Because the Supreme Court is the only court that can definitively say whether this model is constitutional under the Second Amendment. But here's the problem. Getting to the Supreme Court takes years. Wolford was filed in 2023. We're now in 2026, and the case is still in the lower courts. If it goes to the Ninth Circuit and then to the Supreme Court, we're looking at 2027 or 2028 before we get a final answer. And in the meantime, Hawaii's law is the law. Permit holders have to follow it or face criminal charges. And here's another problem. Even if the Supreme Court eventually strikes down Hawaii's law, the damage is done. Other states will have copied it by then. And each of those states will have to be sued separately. We'll have to fight this battle in California, in New York, in Illinois, in every state that passes a copycat law. That's years of litigation and millions of dollars in legal fees. And gun owners will suffer the restrictions in the meantime. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these critical legal updates first. Click that subscribe button right now because the cases I'm covering next month could determine whether you can carry in your own state. Don't miss it. Now let's talk about what this means for property owners, because there's another side to this. Some business owners actually want to allow guns on their property. They're pro-Second Amendment. They don't care if customers carry. But under Hawaii's law, they're forced to take a public stance. They have to post a guns allowed sign, and that's risky. If they post the sign, they might alienate customers who are anti-gun. They might face protests. They might get bad press. So even though they don't object to guns, they're not going to post the sign, and that means their property is off limits by default. The law forces business owners to choose sides in a culture war, and most businesses don't want to do that, so they stay silent. And silence means prohibition. Let me give you a hypothetical. Imagine a small family-owned restaurant in Hawaii. The owner is a gun owner himself. He has no problem with customers carrying concealed, but he doesn't want to post a guns allowed sign because he's worried about backlash. So he just doesn't post anything. Under Hawaii's law, his restaurant is now a gun-free zone, even though he personally wouldn't mind guns. His silence created a ban he doesn't actually support. That's the perverse effect of this law. It forces prohibition even where no one wants it. Now, let's talk about enforcement, because this is where things get really messy. How are police going to know you're carrying on private property? In most cases, they won't. If you're carrying concealed, no one sees the gun. But here's the problem. All it takes is one mistake. Your shirt rides up. Someone sees the outline. They call the police. Or you're involved in an incident. Someone bumps into you and feels the gun. They report it. Or you have to use your gun in self-defense. Now, the police are investigating. And the first question is, did you have permission to carry here? If you say no, or if you can't prove permission, you're getting charged. Even if your use of force was justified. Even if you saved a life. You're still getting charged with illegally carrying on private property. And that charge might be dropped eventually, but you're going to spend thousands on a lawyer. You're going to lose your permit during the investigation. And your life is going to be turned upside down. This is the chilling effect of Hawaii's law. Permit holders are so scared of getting caught somewhere they're not supposed to be that they just stop carrying altogether. And that's the goal. The state can't ban guns outright because of the Second Amendment. So they make it so complicated and so risky to carry that people just give up. Now let's talk about the timeline, because this case is going to take years to resolve. Here's what I'm predicting. Sometime in 2026, the district court will issue a ruling on the merits. If the court rules for Hawaii, the plaintiffs appeal to the Ninth Circuit. The Ninth Circuit hears the case in 2027. If the Ninth Circuit upholds the law, the plaintiffs petition the Supreme Court. The Supreme Court decides whether to take the case in late 2027 or early 2028. If they take it, oral arguments happen in 2028, with a ruling by mid-2028. That's the best case scenario. Worst case, the Supreme Court doesn't take the case, and Hawaii's law stands. And other states copy it, and we're stuck fighting state-by-state battles for the next decade. This information could literally determine whether you can legally carry in public in the next few years. Subscribe now, because I'll be covering every development in this case as it happens. Hit that subscribe button so you don't miss the updates. Now let me give you the action steps you need to take right now. First, if you live in Hawaii, you need to understand that the vampire rule is the law. You cannot carry on private property open to the public unless there's a guns allowed sign. Period. Don't risk it. Leave your gun in your car or at home. Second, if you live in another state, watch for copycat bills. If your state legislature starts considering a law like Hawaii's, you need to contact your representatives immediately. Tell them you oppose it. Make your voice heard. Third, support the organizations fighting Wolford versus Lopez. Donate to SAF, FPC, or other groups involved in the case. These lawsuits are expensive and they need funding. Fourth, if you're a business owner, consider your stance. If you support the Second Amendment and you want to allow guns on your property, post a sign saying so. Don't let the default ban speak for you. And fifth, spread the word. Most gun owners have no idea this case exists or what's at stake. Share this video, share articles about Wolford, make sure people know what's happening. Because if we lose this fight quietly, the vampire rule will spread. And caring for self-defense will become functionally impossible in half the country. Look, I spend hours every week following cases like this, reading court filings, and breaking down what it means for gun owners so you don't have to. The least you can do is hit that subscribe button to support this channel and make sure you never miss a case that could eliminate your carry rights. Subscribe right now, and if you found this helpful, share it with every concealed carry permit holder you know, because they need to understand what's coming. Remember, this is educational information based on Wolford versus Lopez and Second Amendment law. It is not legal advice for your specific situation. Always consult with a qualified attorney if you have legal questions. Stay informed, stay vigilant, and watch this case closely, because the outcome will shape gun rights for a generation.